In late 1996, Princess Diana wrote a letter to her butler, Paul Burrell. She told him to keep it, just in case. In it, she described a fear that someone was planning to stage a car accident, one involving brake failure and a serious head injury, to clear a path for a remarriage. She died 11 months later in exactly that kind of crash. That letter stayed hidden until 2003, and the trial that finally forced it into the open collapsed before anyone had to answer for it. If this letter existed, who else knew about it, and when? The letter Diana wrote to Paul Burrell in October 1996 was not vague. She described, "This particular phase in my life is the most dangerous," and wrote that someone was planning an accident in my car, brake failure and serious head injury in order to make the path clear for Charles to marry. That is the specific language. Not a general fear, not a feeling, a method, a motive, a predicted outcome, written down, sealed, and handed to her butler 11 months before it happened. The newspaper that first published excerpts of the letter said Diana had named the person she believed was plotting against her, but printed a photograph of that portion of the letter with the name blacked out, citing the risk of a lawsuit. So even in the moment of disclosure, the most important detail was withheld. The name stayed hidden then. It has stayed hidden since. But the Burrell letter was not the first time Diana had made this claim in writing. On October 30th, 1995, a full year before Diana wrote to Burrell, her personal legal advisor, Victor Mishcon, attended a closed-door meeting with Diana and her private secretary, Patrick Jeffson. During that meeting, Diana told Mishcon that reliable sources, whom she would not name, had informed her that by April 1996, efforts would be made to either get rid of her or injure her severely enough to make her appear unbalanced through a car accident, specifically via brake failure. Mishcon prepared a contemporaneous note of the meeting. 2 documents, 2 different years. The same method described in almost identical terms. On September 18, 1997, just weeks after Diana died in Paris, Lord Mishcon met with Metropolitan Police Commissioner Sir Paul Condon at New Scotland Yard and read the note aloud to him, emphasizing he was acting in a private capacity. Condon reportedly chose not to disclose it, instead keeping the document locked away in a police safe, where it remained for 6 years. It was not passed to the French investigators conducting the inquiry in Paris. It was not entered into any original inquest proceedings. It sat in a safe. Lord John Stevens, who later led Operation Paget, the British police investigation into Diana's death, confirmed, "The letter was given by Lord Mishcon to my predecessor, Paul Condon, and he put it in his safe. I was only made aware of that when I was made commissioner myself." When the coroner announced the inquest, Stevens said he made sure the letter was immediately handed over. 2 separate documents written a year apart by 2 different people in 2 different settings, both describing the same method of killing, a staged car accident involving brake failure, were both withheld from the people officially tasked with investigating her death. That is not a coincidence that requires interpretation. That is a pattern that requires explanation. Now, I want to be precise about what this means and what it doesn't. Mohammed Al-Fayed alleged for years that there was a coordinated royal conspiracy, that Diana was pregnant, that an engagement was imminent, that MI6 had issued orders. Operation Paget investigated those specific claims and concluded with what it called 100% certainty that there was no conspiracy to murder Diana and that her death was an accident. That finding is on the record, and it deserves to sit there plainly. But here is what else is on the record. Operation Paget's own findings, all 832 pages of them, released in December 2006, confirmed the Mishcon note's existence and the circumstances of its delayed disclosure. That is not a fringe claim. That is the official report acknowledging that a document describing Diana's predicted death was handed to the Metropolitan Police the day after she died, and then placed in a safe where it remained, undisclosed, for 6 years. The letters are the visible part of this story. What the investigation chose not to follow, the blacked-out name in the Burrell letter, the reliable sources Diana cited to Mishcon but refused to identify, that is the part that still doesn't have an answer. 2 documents written a year apart, both describing the same method, a staged car accident, brake failure, and both withheld from investigators. Does that feel like an oversight to you? Or something else? Drop your answer in the comments below. Because the letters themselves are only half the story. What Diana told Mishkan about her reliable sources is where this gets harder to explain. The Burrell theft trial was halted in November 2002, not because the case fell apart on its merits. The trial collapsed following an intervention from Queen Elizabeth II, who stated that the butler had informed her after Diana's death that he was in possession of a number of royal items for safekeeping. The charges were dropped. And here's the detail that matters to this spine. The letter Diana had written to Burrell, the one describing a planned car accident, brake failure, a specific motive, was about to become central to the proceedings. It became public only because the trial ended, not because anyone decided it should be seen. No one chose transparency. The trial's collapse forced it. A letter predicting Diana's death in specific terms sits hidden for 6 years. A criminal trial creates the conditions under which it might finally be examined under oath. Then the trial ends, abruptly, unusually, before that examination happens. The letter surfaces in the press instead of in a courtroom. And the name Diana wrote in that letter, the name the newspaper photographed and then blacked out before printing, never enters the public record at all. That name remains the thread that keeps not getting pulled. Alongside the letters sits another anomaly, one that doesn't involve documents at all, but that sits alongside them in a way that's hard to dismiss. Henri Paul was the driver of the Mercedes that night. His blood alcohol content level was found to be between 1.73 grams per liter and 1.75 grams per liter, a figure more than 3 times the threshold for drunk driving under French law. That is the official number. That is the number that anchors the accident explanation. Here is what the British inquest surfaced about that number. In November 2006, Lord Stevens met with Henri Paul's parents and informed them that their son was not drunk and was found to have indisputably consumed 2 alcoholic drinks, verified by bodyguards, 2 barmen, till records from the hotel bar, and a drink bill. 5 weeks later, the same report stated that Paul was twice over the British drink-drive limit and 3 times over the French limit. Stevens later explained this contradiction by saying Paul did not meet the standard observable definition of being drunk. That is not a resolution, that is a reframe. Friends of Paul testified to French police that he did not have a remarkably high tolerance for alcohol and was observed on social occasions to drink for several hours while exhibiting obvious signs of intoxication. If that is true, a blood alcohol level of 1.74 grams per liter should have been visible. The people who saw him in the hotel that night said it wasn't. I am not telling you Henri Paul was sober. I am telling you that the official blood alcohol figure and the eyewitness accounts of his behavior that night have never been reconciled in a way that satisfies the basic question they raised together. The British inquest jury delivered its verdict in April 2008. They returned a finding of unlawful killing due to grossly negligent driving. They did not exonerate the pursuing vehicles. Unlawful killing, not accident, not misadventure. The jury heard all of it, the letters, the Mishkan note, the toxicology dispute, and still landed on that phrase. 2 documents describing a specific method of killing, both withheld from investigators. A trial that collapsed before the letters could be examined in court. A toxicology report that eyewitnesses cannot square with what they saw. And an inquest verdict that says unlawful killing without saying who was unlawfully responsible. I am not telling you what happened in that tunnel on August 31st, 1997. I am telling you that the documents Diana herself left behind were handled in a way that makes the official explanation harder to accept, not easier. There is one question the Mishkan note raises that no official inquiry has ever directly answered. Diana named in that document the people she believed were planning this. She described them as reliable sources, people close enough to know, specific enough to warn her about a method and a timeline. Those names have never been made public. As of 2026, they still haven't been. And no one in an official capacity has ever explained why. Subscribe if you want to keep following this. The next video goes somewhere you won't expect.